How are you going to not use?
Well, I'm going to try to stay busy, and everyone in my whole circle, I mean, everyone was giving me ultimatums already. So, I mean, you said everything happens for a reason, and I am very grateful for the intervention. And I mean, if I were to pick that stuff up again, my dad will be gone, my fiance will be gone, everyone will be gone, and I'll probably be gone too. That's all I can tell you. I don't.
I got you. Fleming, when it was actually interesting when you gave your admission to the court, because usually a lot of people skirt around and to try to hide, to try to do you. It was almost like when you gave it, and you said this way, you were tired of doing that, and you just admitted it.
Yeah.
You didn't know what was going to happen. You just said, "Yeah, that's what I was doing."
Yeah.
And I appreciated that.
Judge Forshow Feaster, Assistant Public Defender, on behalf of Miss April Fleming, who is approaching the podium. Please
State your name, ma'am.
April Fleming.
All right, what are we doing?
Case, Your Honor, I believe she met with Mr. Brown in custody yesterday. There is a plea resolution. I'm turning to the court, Your Honor.
All right, plea form indicates that she's going to plead guilty to the charge of retail fraud third degree, which is as charged. She's agreed to pay restitution in the amount of $65.62. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Judge.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name, please.
April Fleming.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Sir.
You're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
Date of June 17, 2025. Location of Myers in Pittsfield Township. I think it's 3825. Yes, 3825 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
I put stuff in my purse.
And
Okay.
to take it.
Yes. Yes.
So you walked into the store, you put stuff in your purse, and tried to walk out?
I was grocery shopping too, but I stole some stuff too.
All right.
Yeah.
So the stuff in your purse,
Yeah.
was that stuff that was offered for sale by Meyer?
Right. Yes.
You didn't have anybody's permission to take that property, did you?
No.
And the store was open to the public at the time when you did this? All right. Ma'am, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Nothing before.
So on the record, Judge.
All right. And have I complied with the court rule?
Yes, Your Honor.
I believe you have, Judge.
All right, court will accept the defendant's plea of guilty to this charge.
Judge, I believe Mr. Brown wanted us to request the court consider immediate sentence.
What else does she have? I usually don't do it on these cases, but
My understanding is there's nothing else holding her. She's been in custody for 63 days.
there's nothing else holding her?
That's
Not that I see.
All right, so here's what I'll do. I'll refer the defendant to probation for pre-sentence investigation and report. And I understand the restitution has been set, but there's an issue regarding that. Sentencing in this matter will be
March 11th at 9 a.m.
March 11th, 2026, 9 a.m. So nothing else is holding you?
No.
What's her bond in this case? What do we have?
Your Honor, bond was denied on this matter.
Yeah, that's right. All right. Ms. Fleming, what do you think my biggest worry if I let you out is?
That I use drugs.
Yeah, but the drugs you're using,
Yes, in particular, are very dangerous. Very dangerous.
you think that's my worry?
Yes.
On part. My worry is you won't come back. Not that you voluntarily won't come back, but that you'll be dead. That's what worries me.
I understand. I just thought that this would be, that I'd be home by now, you know. I didn't
No.
expect to be here 63 days later.
I didn't think I'd be holding you for 63 days. Right?
Sorry.
I didn't think I'd be holding you for 63 days.
I know. I know.
So Fleming, how are you going to not use?
Well, I'm going to try to stay busy. And everyone in my whole circle, I mean, everyone was giving me ultimatums already. So, I mean, you said everything happens for a reason, and I am very grateful for the intervention. And I mean, if I were to pick that stuff up again, my dad will be gone, my fiance will be gone, everyone will be gone, and I'll probably be gone too. That's all I can tell you. I don't.
I got you. Ms. Fleming, when it was actually interesting when you gave your admission to the court, because you really, usually a lot of people skirt around and to try to hide, to try to do you. It was almost like when you gave it, you said this way, you were tired of doing that and you just admitted it.
Yeah.
You didn't know what was going to happen. You just said, yeah, that's what I was doing.
Yeah.
And I appreciated that. But now I got to figure out, because you're not going to be in it forever. It's clear, right? So I got to figure out how we're going to keep you alive, try to give you tools so that you don't lose everything around you. Most importantly, your life.
Right. And
it just worries me a little bit. I think you understand. I wasn't trying to punish you.
I know.
I'm a little bit worried that, and I'm not saying that's not a good tool that you keep yourself busy, but that you don't have other supports around you.
I mean, I have
to make it
quite a lot of support.
Well, in terms of people.
Yes.
But in terms of treatment and in terms of other.
Right. I mean, I do go to the methadone clinic, and I mean, I'll be willing to do whatever, outpatient. I mean, I'm not sure what exactly to say here. I just.
No, I know. And
this is really hard. I just
What?
really didn't know I was going to be here this long. And everyone around me, everyone I talked to about this in jail and everything, everyone's saying this is so excessive, the punishment for the crime. And I don't know, you know what I mean? I don't.
Those are the ones sitting in jail.
Right.
Yeah.
Right. Well, I mean, it's been the
What the heck
lady
do they
in Community
know?
Corrections would say, everyone's been saying it. And I don't know. I'm not a lawyer, that's all I've been told. I just,
He's just trying to keep you.
Right. I know. And that's what I'm telling them. I'm telling people I'm grateful for this intervention and everything. And I mean, I don't know.
I had a March 11th sentence. There, she said she'd see her.
She said she could be 225.
That's what I want. All right. So here's what I'm going to do. I gave you a sentencing date of the 11th. I'm going to move that up to the 25th of this month, so next week. Okay.
Okay.
My probation department will be down there to talk to you. And that way, what we can try to do is set something up for you, at least give you a framework so that when we let you out, you got some guardrails around you. And you got somebody staring down at you. That would be my probation department. And then you also have me staring at you.
So will I be getting out on the 25th?
That is my hope.
Okay,
That's what I want to do.
okay,
Okay, that's why I'm moving it up. So we can give you all that stuff,
right, and I appreciate that.
try to get you in the right direction and let you out and see how you do.
Thank you. Thank you. I mean, I owe you a lot. I really do.
Thank you for saying that. I don't know that you owe me anything. I'm grateful to you for being so honest and in the point of being so honest that you chose your life over everything else. So I'm grateful for that. All right.
All right.
See you in a week.
Okay.
Thank you, Judge.
Court calls the case, People versus Mark McIntosh.
Morning, Honorable Cook to the people.
First Judge, Court shall fix the Assistant Public Defender on behalf of Mr. McIntosh, who's approaching the podium. Please state your name for the record.
Mark McIntosh.
Please assist the first pretrial in this matter, asking for an adjournment to have time to discuss this matter more with Mr. McIntosh.
March 4th, 2026, 9 a.m. bond.
Might get moved.
Thank you.
All right, thank you, Judge.
Thank you, Judge.
Okay,
Yeah, so if we could get in,
March 4th,
yeah, that's perfect. Thanks, Judge.
2026, 9 a.m. Bond will continue.
Everything's at 9 and then it'll probably change. Okay, all right. I'll be in touch.
Court calls case of the People versus Demetrio Brown. Yeah.
Morning, Honorable
Cummings, I'm sorry. I don't know why I said Brown.
Conrad Siller on behalf of the Township.
Cummings,
Cummings the second.
yes. Must have been the Ronald Brown.
All right, ready-ish, Judge. Torshall Feaster, Assistant Public Defender on behalf of Mr. Cummings. Please state your name for the record.
Good morning, I'm Demetrio Cummings for the record.
Thank you.
Thank you, Judge. I'm looking at our docket. I don't see Mr. Cummings' name on the block. I don't know that he has been. Oh, for noon. Okay. Looks like he has spoken to someone and that they will request an adjournment on the file for further negotiations.
March 4th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Yeah, you have a nice day.
Court calls case People versus Carlos Mack.
People.
Ready, Judge. Torshall Feaster, Assistant Public Defender on behalf of Mr. Mack, who is approaching. When you arrive, please state your name for the record, sir.
Carlos Mack.
Thank you.
Thank you, Judge. This is the case I believe Mr. Mack is trying to get a valid license. He does indicate he needs the court's permission to pay a clearance fee. He's
Here,
that's
Yes, sir.
that's all he needs to do.
that and another. He says in another month he should have his assessment completed and get his license back.
I know I got it today, but I get for my assessment, yeah.
So I guess he needs to pay the fee and he needs another month. If the court will adjourn it for a month, he thinks he could have it back after.
Okay, defendant may pay clearance fee. I'll adjourn this out to March 18, 2026, 9 a.m. That's the last adjournment.
Last adjournment.
Yeah.
All right.
Yeah.
Thank you. So you have to have it back by then. Or we're gonna
Thank you.
Thank you.
Thank you, Judge.
Court calls case People versus Michael Ericson.
Morning, Honorable Cook to the people.
Brian Boyd on behalf of Mr. Ericson.
Hello, Michael J. Ericson.
Your Honor, we're continuing to try to resolve this matter. It's my understanding Mr. Cook is looking into some restitution issues. So if we could get an adjourned pretrial date.
March 4th, 2026, 9 a.m. Bound continued.
May I address bond?
Sure.
Your Honor. He's asking to be, Mr. Erickson's asking to be released on a PR bond if the court would feel it was appropriate. Otherwise, we'd ask for a release for treatment, and I can prepare a proposed order for that if the court was inclined.
I don't need a response. I will not reduce it to a personal cognizance. I'll leave the bond where it is. I will sign a release to treatment.
Wonderful.
Aesthetic.
Thank you, Your Honor.
Thank you.
Let us know.
Court does call the case people versus Adam Martinez.
Morning, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Martinez, just state your name for the record.
Adam Martinez.
Judge, we have a resolution in this matter. There's a proposed plea
form in front of me that indicates that he would be pleading as charged.
That's correct, Your Honor. Mr. Martinez has been screened for entrance into the 14A sobriety court program, which he has been approved for. I know he was there last Thursday to observe that program, and is asking the court to accept his plea, and ultimately, hopefully, that's where he'll be sentenced to.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Adam Martinez.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct?
Yes, sir.
That is a misdemeanor punishable by up to a $1,000 fine, up to 1 year in jail. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will? And also because you believe that you're guilty?
Yes, sir.
January 31st, 2024, at the location of Ellsworth near Carpenter Road, in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
Do you know how much you had and what you had?
I had a fifth of vodka.
Fifth of vodka?
I'm not sure how much I drank of it.
Okay. Were you stopped by the police or was there an accident?
It was an accident.
What happened?
I don't remember, to be honest. I just woke up in jail.
All right. Wow. We're gonna have a problem. So you had the accident, don't remember anything after the accident?
Not really sure, no.
Okay. I'm gonna stop the plea at this point. What I would do, counsel, if during my next break, so that we can get this gentleman moving, if somebody will provide my office police report, I'll take a no contest plea.
Wonderful, Judge. I have it right here. I'll send it to your staff.
All right. All right. So I'll call it up. You have to give me a chance to review it. Court calls the case People versus April Fleming.
Morning, Your Honor. Raymond Cook for the people.
He asks, "How are you going to not use?" She pauses and says she'll stay busy because if she goes back to that life, she'll lose her dad, her fiancé, maybe even herself. She admits everything openly, no excuses, no hiding. The judge notices it. You didn't skirt around it. You just said yes. You were tired. In a courtroom full of denial and deflection, honesty hits different. Sometimes the turning point isn't the sentence, it's the moment someone finally stops running from the truth. So here's the question. Does real change start the moment someone admits what they've been hiding? Like if honesty matters in court? Share. If accountability is the first step to redemption.
That's a good motion.
Yeah, I think he was released to treat, so he was not talking. So to my knowledge, I don't know exactly where he's at. From my past dealing with that guy. Yeah, we resolved pressure. So took off the need. But in the course of us resolving her case, he was all giddy. He was giddy released.
All right. 14A District Court, County of Washington, State of Michigan is now back in session. The Honorable Judge J. Simpson.
May be seated. Whoa.
Right, it's like seven.
You worked at your age care? Court does call the case, people versus. Really? Joshua Wara.
Morning, Reagan Cook for the people.
Morning, Judge. Lawrence Margolis with and on behalf of Mr. Wara, who is approaching. Josh, please state your name. Judge.
Joshua Wara.
Thank you, sir.
Judge, I am recently substituted into this matter. It is the date and time for a pretrial. The prosecutor has informed me that there are there's one new charge, a misdemeanor coming out of 14B that has not been, has it been set for arraignment?
Yes, so he has it's not a new OWI, it was recently charged. He has an OWI set for arraignment on March 24th out of 14B. He also has a felony matter set for April 2nd for a competency review. I believe we're just asking for an adjournment. We're trying to push up the arraignment on his 14B matter so we can get arraigned on that. We can do a global resolution with all three of his cases.
All right.
Correct.
The 18th would work, you think, or?
Hopefully,
March, Judge.
I'm not familiar with 14B's policies on moving up arraignment dates, but I'm going to try and get that worked out. So we will try and make the 18th work.
And I'd also let your office know of, I believe the competency report has concluded, or the evaluation was done. I believe he was found competent to proceed. I don't believe the report has been received yet. Have you received that yet, Mr. Cook?
On the felony matter?
Correct. And
I've received, he was found competent in this matter.
Yes.
So.
Okay.
I don't know why the same wouldn't occur in the.
And I agree, and we'll handle that and get that report to the court.
All right, very good. March 18th, 2026, 9 a.m.
Thank you, Judge.
Time continued. Thank you. Court calls the case of the people versus Zachary Johnson.
All right,
so on behalf of Cecil Township.
Brian Bowling on behalf of Mr. Johnson, Your Honor, can you state your name for the record?
Zachary Johnson.
Your Honor, we've resolved both of these matters. There should be an executed plea form in the file ending in 0618, where Mr. Johnson would plead guilty as charged to the failing to report an accident with fixtures. And with respect to case ending in 1025, Mr. Siller's been kind enough to offer a plea to double parking in that matter, based on Mr. Johnson showing a valid driver's license. So he would plead responsible to double parking in that case.
That is correct, on behalf of the township.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Zachary Johnson.
Sir, it is this court's understanding, and starting in case ending in 618, that you are going to be pleading guilty to the charge of failure to report an accident to fixtures at punishable by up to 90 days, $100 fine plus court cost. Do you understand that, sir?
Yes, sir.
Exactly. And and to that charge, how do you plead, sir?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
I am.
of your own free will
Yes, sir.
and because you believe that you are guilty of this offense?
I do.
February 29, 2024, at the location of South State Street near Runway Boulevard, Pittsfield Township, Washington County, State of Michigan. Were you operating a Ford Focus?
I was.
And what happened?
I was on my way to do some Uber Eats and I was gonna stop at the Speedway over there, get some coffee. It was, late at night and I just half dozed off for like 2 seconds and hit the curb and it was chaotic after that. Totaled the car.
And did you hit a utility pole?
I did, yeah.
All right, and it damaged that utility pole
It cut it in half. Yes, it did.
with a Focus?
Listen, man, that Focus saved my life and I am lucky.
No, that's
man.
fine. I'm just thinking.
I don't know how it.
Think how better it would have been with the 150. Anyway, never mind.
Man,
Not saying.
if the 150 might have survived, who knows, man?
All right. So, and after that, did you report that accident to the nearest and most convenient?
I did not. No.
All right. You didn't report it in any way.
No.
Correct. All right. Counsel, do you believe that I complied with the court rule? Would it be proper to accept this defendant's plea regarding that charge?
Yes, Your Honor.
And sir, on the date of July 1st, 2022, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, you admit responsibility to double parking a motor vehicle?
I do.
All right, court will accept that admission. This is in case 1025. It will accept the admission to count 2. Count 1 is dismissed. In that case, sir, fines and costs of $180. In your other case, is there anything you want to say before I do impose sentence?
No, sir.
Fines and costs of $250. When can you pay all of that?
By next Friday.
27?
Yes, sir.
Pay it by the February 27th in both matters. And in the case ending in 6/18, I'll suspend 90 days in jail.
Thank you.
Thank you.
Thank you, Your Honor. Thank you, sir.
Take care. Drive safe. Go ahead, boy. Court calls the case, People versus Devonte Belchure.
Morning, Your Honor. Raymond.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Devonte Belchure on one of the cases.
Attorney speaks to Mr. Defender on behalf of Mr. Connor Belcher on the remaining files.
Sir, your name?
Devonte.
Thank you. What are we doing?
Your Honor, please.
So, Your Honor, Ben, I believe this is going to be signing a plea form that should be in front of Your Honor in just a second. The central nature of that plea is file ending in 1722 with agreement to 2001 to 94.
Hang on. 1782, he's going to be pleading on.
Correct. With an agreement to $1,194.39 restitution. In exchange, the people would be dismissing the files ending in 1243, 1112, 1234, and 1370.
So all the remaining files.
Correct.
All right, I have a plea form in front of me that indicates that the defendant would be pleading to the charge of retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, the case is referred to by the prosecutor will be dismissed, the other 4 matters. And he's also agreeing to pay restitution in the amount of $2174.39. That's the court's full understanding of the agreement.
My handwriting might be bad. It was 2,194, not 74. My apologies.
Oh, that's a 9. So 219439.
Correct.
Pardon?
That is a complete.
All right. May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the whole truth and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Devonte Belchure.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
Negative.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes.
You understand you're giving up your right to appeal of right.
Mm-hmm.
Is that a yes?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
Negative.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of this offense?
Yes.
August 18, 2025, location of 3145 Ann Arbor Saline Road in Pittsfield Township, Washington County, State of Michigan. What do you do at the Meyer that makes you think that you're guilty?
I walked into that Myers, grabbed sports cards and some sushi, and I walked out and did not pay for those products.
All right.
Yes.
So when you say sports cars, toy sports cars or
Sports cards, trading cards.
oh, cards.
Yes, sir. I'm sorry.
Gotcha. Okay, cards. And tried to walk out without paying for them.
Yes, sir. Sure.
All right. Was the amount that you attempted to walk out with in excess of $200?
Yes, sir.
All right. Store was open to the public at the time?
Yes, it was.
You didn't have anybody's permission to take that property, did you?
Negative. No, I did not.
And this property you took was property that was offered for sale by Meyer?
Yes, it was.
All right. So I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Yeah, Your Honor.
It's on record, Judge.
All right. And have I complied with the court?
Yes, Your Honor.
Yes.
Yeah, Judge.
All right. Court will accept the defendant's plea of guilty to that charge as contained in case ending in 1782. The case is ending in 1243, 1370, 1112, and 1234 are dismissed pursuant to that plea agreement. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing will be. All right.
Yeah.
March 11th, 2026, 9 a.m. Bond.
You have a lovely day, sir.
You do the same. Thank you.
Thank you, Judge.
Court calls the case of the People versus Matthew Wallace.
Your Honor, Raymond Cook for the people.
County Auditor on behalf of Pittsfield Township.
For the Judge Torres fees for Assistant Public Defender on behalf of, but I do not believe I am with, Matthew Wallace. Matthew Wallace. Your Honor, we have not had any contact with Mr. Wallace. For the record, I will request an adjournment, but I do not know why he is not present.
Then tomorrow we'll issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10% on each case. Those warrants will issue immediately. Thank you. Calls the case, People versus Crispin Anthony.
Raymond Cook to the people.
I get the wrong one.
Brian Bowling, Assistant Public Defender on behalf of Ms. Anthony. Can you state your name for the record, please?
Kristen Nicole Anthony.
Judge, with respect to the pretrial, we're seeking an adjournment. It's my understanding Ms. Anthony is scheduled to see Judge Hammoud on the 23rd. So we'd like to come back after that date if at all possible.
23rd of
February. Yes, I'm sorry.
Adjourn this to March 4th, 2026, 9 a.m.
May I address bond?
You may.
Your Honor, Ms. Anthony would like to consider the court, or would like to ask the court to consider granting her a personal bond in this matter. She is 39 years old. She's a resident of Wayne. She is single, but has two children, a 10-year-old and a 12-year-old. And she's currently a student at Wayne State University studying business there, Your Honor. Ultimately, it's my understanding that the court granted a release to treatment on the other matter. So if we were unlikely to grant a PR bond in this case, we would ask the court to consider mirroring the release to treatment order in this matter to coincide with the other case.
Your Honor, I have no objection to release to treatment. I would, for the record, looking at actually, I do out of county schools, including one for here on a tether. It looks like a couple of retail frauds. She has 2 bonds and 9 holds. So I think that a PR bond would be appropriate, but release to treatment with tether, I think, would be appropriate.
I will not change her bond in this case and give her personal recognizance. However, I have no problem signing an order for release to treatment with the GPS.
Wonderful. Thank you, Your Honor.
Thank you.
We'll be in touch with Anthony.
Court does call the case, People versus Ishmael Davis.
Morning, Your Honor, Raymond Cook, the people.
Want to do it?
No, I got it. Correction, Judge George Showpiece, the Assistant Public Defender on behalf of Ishmael Davis, who I do not believe is present, Your Honor. Mr. Davis, from our notes, was in custody. Apparently, he bonded out. He is not apparently in the courtroom today.
Based on my interaction with him before Judge Fresh Hours, that's my understanding.
Mr. Bowling has additional information, Judge. He believes Mr. Davis may be in inpatient treatment based on his other case in front of Judge Fresh Hour. So
what Bowling told you?
I'm just a parrot today, Judge. So
You want to be able to check that?
yes, Judge.
I'll adjourn it to March 4th, 2026, 9 a.m. Defendant may be in treatment. If he's not, I'm locking up Bowling.
Fair enough, Judge.
Feaster didn't even try to protect. Court calls the case of the People versus Deshour Bon Sanders.
Morning, Your Honor, Raymond Cook, the people.
Ready again, Judge. Portia, the Assistant Public Defender on behalf of Deshour Bon Sanders, who is approaching. Please state your name for the record, sir.
Deshour Bon Sanders.
Thank you, Judge. My understanding is Mr. Brown met with Mr. Bon Sanders yesterday. We're setting this matter, we're asking the court to set this matter for final settlement conference and jury trial. I believe Mr. Bon Sanders is going to personally request to dismiss this matter. I don't know that he completely understands how the procedure works, and maybe the help explain it to him. But he's requesting a dismissal. Assuming the court does not grant that, we'd be asking for a final settlement conference and jury selection, Your Honor.
You have something you want to say?
Yeah, I mean, since I've been having all of my my other ones in front of you, like they haven't been shown up to court, so I don't see why it would be an issue.
You don't what?
On PR bond.
Why this wouldn't be a PR bond?
But they haven't been showing up to court, and all my others have been getting dismissed as well.
It was probably because, when was this one? Was this one picked up while you were on bond on other cases?
I'm sorry,
Was this case picked up while you were on bond for any other cases?
I'm not sure.
Okay. I'll defer to the court, but from what I recall reading in the notes, Your Honor, I believe this started out as a felony. I believe it was reduced and remanded at exam as a result of the complaining witness not appearing. I believe Mr. Bon Sanders has a 100 bond in his file. I believe he is requesting that the court consider a personal bond after the court determines where the court's going to set this matter next.
Your Honor, the notes that I have from arraignment indicate that at the time of arraignment, at least he was on bond 14G and was denied that case. Looks like, looking at Mr. Zenda's notes, there were some issues with phone privileges at the jail for this defendant. I would ask upon to continue. I believe right now it's set at $1,000 cash and surety. As soon as he was providing proof of some sagging on that, there is that he gets exclusion of tether of the entirety of Washington County. I don't know if he has proof of that address.
My client does indicate he has proof of his address he would go to in his pocket here, Your Honor, if the court would consider the PR bond. He does indicate that he has permission and a valid place where he can go, should the court decide to release him. He's around.
I'm not going to release him.